Okay, so let's quickly research a release of liability that wasn't read but signed. How many of us have done that? I know I certainly have, even after being an attorney. So that's the issue, is whether the failure to read it could be a defense. Some keywords would be release. A synonym of that is waiver or exculpatory clause. Keywords would also be read and failure to read, things like that. So I took this into Lexis, and let's do release within the same sentence as read. And I set, by the way, our jurisdiction to Michigan. And now I'm going to filter to just case law. And we get 345 cases. That's nuts. So I'm going to try a different search. Release within the same sentence, and then within the same sentence as fail. And I did the expander there. By the way, I'm going to choose Michigan again. I did the expander there, the root expander, the exclamation point. So you get failing to read, failure to read, failed to read, all permutations of the root FAIL. Now 25 cases, that's much better. And we can even go down even more. I'm going to click on reported, and that will get us down to 10 cases. Now that's a manageable list. So there's some good ones here. She failed to read it. So if you found Gara could be a really good one. So let's click on that. And let's see, the facts are injured person went to a tavern, sumo wrestling event that's close to our Velcro wall. The release did not apply because she failed to read it. So let's go see what the court says about that. So just very quickly, it says it wasn't a mistake. She didn't read it. That's her own fault. So too bad, so sad. So Gary's a good one. And they cite Dombrowski, I noticed here. So if we look at Dombrowski, we might get a little more on this rule. And actually, I was looking at this earlier. And again, similar facts where somebody didn't read the release and they got injured. And this one here states a black letter rule. One who signs a contract cannot seek to invalidate it on the basis that he or she did not read it or thought that its terms were different, absent showing a fraud or mutual mistake. So there you go. So now you know, in Michigan at least, if you don't read it, too bad, so sad, you're out of luck. So Gara or Dombrowski were really good cases for that, very factual or very similar facts. Maybe you found something else. You can always email me or email a professor or put it into the exercise and get some feedback on it.